I'm Joel Oliver. I'm Anna's mentor. I want to tell you a bit about predictive memos, sometimes called legal research or office memos. Students and junior lawyers are frequently asked to research legal issues, and they spend considerable time writing memos for senior lawyers who use the memos to make decisions on client matters. But really, what are memos? They're confidential, internal documents that record, they research, analyze a legal problem, and predict the likely outcome should the matter go to court. So your work in the memo will often be the basis for other work by the senior lawyer who may be writing on advice matters or drafting litigation documents, deciding negotiating positions, and so on. A good memo really will give the assigning lawyer confidence in your work and will establish you as a member of the legal team. So it's really important to do a good job on this memo. To be effective, your memo needs to be objective, specific, thorough, and accurate. But most importantly, your memo needs to give an answer to the question asked. This means a great deal of thought needs to go into the content and the way you communicate your ideas. So that's why I tell you to pay attention to context, audience, and purpose. Before you can even start to write, you need to know a few things. What is happening in your client matter? Why are you writing, and who's going to read your work? The answers to some very basic questions will lead you to make writing choices about everything from level of detail about the facts and the law, the organizational structure of your document, to word choice, tone, and basically to what font you choose and how much white space to leave on the page. But every single thing you do as the writer of that memo should be driven by your answers to these three questions. Let's talk about context. What is the context? Context is both the client's overall story and where the particular memo fits in the client's legal matter. Every client story is unique, but some questions will be common to most files. For example, it's going to be important to know if your memo is for a new or ongoing matter, a highly contested or adversarial matter, a matter connected to other files in the firm, or an upcoming court appearance. Each of these will lead you to make different choices. You're going to also need to ask yourself where this memo fits in the overall progress of the file and how your memo will be used. Say you're being asked to research a question on admission of evidence. To do a good job, you need to know whether the senior lawyer might be preparing the litigation documents for a motion based upon your memo. You'll need to know whether your firm is bringing the motion or responding to it. You will need to know whether the motion is pre-trial or is coming up in the course of an action. So immersing yourself in the details and asking the right questions will ensure that you research the right questions and get the right answers in the right time. Audience, who is going to read this and what do they need from you? You make many writing choices based on who will be reading your memo. Because these memos are confidential internal documents, you can expect there to be a limited and controlled number of people who will see it. But you will need to identify and consciously address the needs of those readers. It should be no surprise that the senior lawyer who assigned you the memo will be your primary audience. And you can assume that your senior lawyer has several characteristics. They don't have a lot of time to read and reread research memos or do the research you were asked to do. In fact, the senior lawyer hopes to use your memo to save time and manage the case efficiently. So you need to anticipate that your reader needs a solid analysis of legal issues, a good overview of the cases without having to read all the authorities, an analysis that anticipates and deals with both strengths and weaknesses, an analysis that anticipates counter-arguments and deals with them, and most importantly, a clear bottom line and an answer to the question you were asked. You can also assume that the lawyer is a careful and skeptical reader. As they read, senior lawyers mentally test out what you have written against their own knowledge or hypothesis about the file. So you know that your analysis needs to be accurate and communicated clearly. A third point, the senior lawyer is knowledgeable. Senior lawyers can handle complicated material and will know the legal terminology. What they're looking for from you is an analysis of the material based on the facts of the case and the law that you've discovered in your research. And you have to write it concisely and precisely. Finally, the senior lawyer needs details and needs you to do a thorough job. This means complete names of cases, proper and full citations, useful quotations, effective case summaries, a focus on material facts, and relevant details. Your attention to detail will make the difference between a useless memo and one where the senior lawyer can confidently take the next steps. And then there's other readers you need to think about. Although you write your memo for the primary audience, usually your assigning lawyer, you should be aware of other and future readers. For example, there may be a litigation team working on this case as it progresses, so there's going to be several lawyers that may need to read and use your memo. Most firms have a data bank of research memos to keep track of all the research done in the firm. So cases coming up in the future may raise similar issues, and other lawyers in the firm may be looking at your memo to see if the research can help them. So that means you write in a way that anyone picking up the memo will be able to easily understand the context, the problem, the analysis, and most importantly, the answer. Lastly, some firms share memos with clients, usually the more sophisticated or legally trained clients, but you'll need to check on this possibility and write so that readers outside the firm will also understand your analysis. Let's talk about purpose of the memo. Memos are written to help someone make a decision. They're not academic papers. So first, you need to find out what this memo will be used for. Just as every client story is different, there's going to be a different purpose for your memo. For example, a lawyer needs a general update after a recent change in the law in order to give advice to a client. Or the lawyer may be considering next steps in a client file and needs to assess options. The lawyer may be planning to write a case comment to reach out to clients in the firm's website or a newsletter and needs some background analysis from you. An important one is the lawyer is deciding whether a particular claim is worth a client spending any money pursuing it. At the end of the day, you consciously make writing choices to deliver on your purpose.